Welcome, everyone, to the University of New Mexico Law and Mental Health series. This is weekly discussions of practice and science featuring experts in behavioral health and the law. This series is run by the Division of Forensic Behavioral Sciences of University of New Mexico's Department of Psychiatry and Behavioral Sciences in support with the New Mexico Behavioral Health Services Division. I'm Anthony Perillo, the Forensic Psychology Training Director here at the University of New Mexico. For our talk today, if you have any questions for our presenter, make sure you enter them in the Q&A box. Anytime you feel comfortable, do know that we hold questions until the end, and oftentimes it's not possible for us to get to all of them. If you are pursuing continuing medical education credits, there will be a sign-in sheet posted in the chat box shortly, so keep your eye on the chat box. Same thing for those of you that are pursuing APA continuing education credits. The chat box will be where you see the link, but that link will be posted later on in the latter portions of the presentation. Make sure that you check that link before you leave the webinar. If it's not working for you, copy it and bookmark it, and make sure that you save your certificate after you complete the survey because we don't have access to those certificates after the fact. If you missed last week's talk in the series, Dr. Kevin Richards' helpful discussion of ethical and professional considerations of working high-profile forensic cases is now available on our YouTube channel. The recording for this week's talk should also be available on our YouTube channel later this week, and the content slides will be accessible for people registered for the series later in the week as well. As a heads up for next week's talk in the series, we have Dr. James Andretta, who will be discussing identification of survivors of child commercial sexual exploitation. But coming back to this week, I'd like to introduce you to today's speaker, who will be discussing assessing substance use allegations in high conflict family court cases. This is Dr. Bill Frankenstein. Dr. Bill Frankenstein is a licensed psychologist with a general clinical outpatient private practice in Red Bank, New Jersey, with a specialization in varied roles mental health professionals occupy at the interface of family law and psychology. He previously worked at the Center of Alcohol Studies at Rutgers State University of New Jersey, and he's used his training in addiction studies to develop and now share a multivariate assessment model to help litigants, lawyers, and courts more objectively assess the validity and relevance of substance use allegations for child protection and best interest cases. So Dr. Frankenstein, on behalf of the University of New Mexico, we're very excited to have you joining our series and thankful that you'll be sharing your expertise in this particularly concentrated critical issue with us today. I will go ahead and throw it over to you.
Thank you, Anthony. So let me just scroll through the administrative slides. Now that is, it seems to not be working again. My scroll function.
All right, if it's not working, I might have you exit the shared screen version again and pop it up, and we'll see if that kind of continual flow will help this time.
Stop share?
Yeah, stop the share, and then you can share it right back.
Okay, and
yeah.
Where's that share? Okay. Okay, great.
Yeah, it's moving now.
So I don't have any financial arrangement. Okay. So what I'd like to do is also acknowledge this. What I'm going to present is really constitutes 25 years of work together with a colleague of mine, Jim Longenbucker. Jim and I were graduate students together at Rutgers. We served as faculty together at Rutgers. Jim passed away a couple of years ago. He stayed in and had a career as an academician. I left academia, became a forensic psychologist, which is a little bit like, it's like being an academician without having to be an academician. So we've developed this model really over 25 years. So I just wanted to acknowledge his contribution. So my goals and intentions for this are substance use allegations come up a fair bit in forensic family court type situations, high conflict divorce matters. Depends on the jurisdiction, but generally, I'd say 25 to 50% of divorce cases that are high conflict have substance use allegations as an element. And what I can tell you is the types of situations that call for forensic substance use assessment are often gray area cases. In cases where it's clearly established that a litigant has a serious alcohol and drug problem, that is fairly detectable in courts, and rarely needs this level of analysis. So a lot of this focuses on high conflict cases where there is a lot of he said, she said. Courts just don't know what to do. So my goals are to try to give you technical, practical, and scientific information that can help you model the assessment of substance use allegations in these types of situations.
Bill,
Yeah.
we can hear you, but it is a little bit muted. So we're wondering if your volume can be raised a little bit more.
Let's see. Does that change anything?
Try again.
Does that change anything?
I'm not sure if it did. We can hear you. It's just a little bit muted.
Yeah. Okay, I'll try to be loud.
Okay, fair enough.
This model will be useful in a variety of different contexts. It comes up in child protection cases. The problem with child protection cases, at least in my New Jersey jurisdiction, my county and in New Jersey, is that rarely does the assessor have time or resources to do a fuller evaluation. But this model will be adaptable to other evaluative contexts where you're trying to get some clarity and objectivity about a subject's substance use and abuse. Is that any better, Anthony?
It's about the same for me, but I can hear you clearly.
Okay, well, I'll do my best. So my goals are to do that, to provide you with a model to give you some sense of what the difference between a clinical and forensic substance use evaluation look like in these situations, contextualize this work as a form of risk assessment. I will give you a little bit of background. I'm going to go through it quickly, the science, epidemiology, pathophysiology, and areas of assessment. So in terms of forensic substance use evaluation in separation, divorce, and matrimonial law, these are the basic components of an evaluation. The interviewing, clinical and historical interviewing, which is probably the core foundational aspect of the evaluation, including interviews of the complainant. Very important not to treat the complainant, the spouse who is saying the other one has a substance use problem. Very important to interview them in detail, not just treat them as a typical collateral, but need to drill down and really get information. That's often the first thing I do, because that shapes the focus of the evaluation. The second component would be general psychometrics, things like the MMPI or the PAI or any of the instruments that can give you information on broad personality constructs, different constructs, and importantly gives you information on validity measures that helps you scale how you see the reliability of the information being provided by the subject. Document and records review, and that's a very broad category. It can be anything from treatment records, it can be driver's abstracts, it can be criminal records, it can be certifications. You sometimes, in cases where there's wealth, people will hire detectives to follow someone into a bar and record someone drinking. So any kind of discovery material is an important component. Biomarker assessment and testing for drugs other than alcohol. With alcohol, there are a number of biomarkers I'll go over. And the value of biomarkers is that they're independent of the self-report of the subject. And so it takes it out of the realm of the he said, she said, and gives you information that you can use. It kind of a little bit of hard science you can bring into it, and then communication with collaterals. Lay people, professionals who've been involved. Then I'll go through how you report findings, your findings, conclusions, and recommendations. We'll do Q&A. I thought, it's fun and it's relevant to give you, I call it a pretest, but it's it will shape your understanding of the types of issues that come up in these evaluations. So I just thought it would be fun to do a little bit of this on the front end. So I'll read it to you and give you 30 seconds to go through the answers, and I'll tell you what I think the best answer is. Some of them have more than one best answer, or better answer. So a referred parent's urine drug screen results in positive findings for cannabis with a quantitative level of the metabolite that seems unusually high. So which of the following are true? Take 30 seconds. So the better answer would be C, that the subject has likely used marijuana. It is a high level of metabolites can mean any number of things. And we don't know if the use would rise to the level of a marijuana use disorder based on a quantitative level. And what that gets at is I think one of the core principles in forensic psychology, and certainly a core principle in this type of work, which is the value of convergent validation. So it is rarely the case that a drug test result or a biomarker finding is going to be dispositive for what should happen in a case. There are certain situations in which it can be, but that is rare. Let me go to another. It's question 2. So which of the following types of data might be dispositive of a substance use disorder? Take a couple of seconds for that. So on this one, I think the better answer would be E, detective reports that record the drinks consumed, the volume of the drinks, the time frame, whether the person was eating, what was their comportment, and how to, to the extent that you can assess judgment, like when they got up to get out of the bar, were they stumbling? Did they have 6 doubles in an hour and seemed not to be intoxicated? You could infer that someone who drank at that level in that time frame has developed a considerable dispositional tolerance to alcohol, so it would increase the likelihood that they would meet some of the dependency criteria. D, elevations on biomarkers. Well, those are non-specific biomarkers, and there are other reasons why, even if they're elevated, there are other reasons why they can be elevated. They're not terribly specific. Being intoxicated at a family gathering is simply an episode of alcohol intoxication, and it's not dispositive of anything other than that the person overdrank in one instance. Conviction on one driving while intoxicated charge. I think the data on that is it's certainly suggestive, but many people who don't have an alcohol problem can get a DWI because the threshold amount of drinking to reach the statutory blood alcohol level isn't that much. Now, conviction on 2 DWIs would be much more significant. There, the data is something like 97, 98% are likely to have a substance use disorder. Let's do one more. This is an interesting one. So divorcing parents have a kid who has an ADHD diagnosis. The father is a Wall Street trader, spends a lot of time in front of screens executing split-second trades. Occasionally takes one of the child's Adderall or Vyvanse to increase work concentration. Mother was okay with it when they were together, but once they get separated, the mother argues that the father is a drug abuse whose fitness should be questioned as a function of the substance use. So what sorts of things might be done by an evaluator in this situation? Give you a couple of seconds. So I think the better answer here would be F, A through D. All of these are relevant. You would want to do forensic quality drug testing to objectify whether the person is using any other substances. And it should be forensic quality, preferably by hair or fingernails, because you have the advantage of the longer look back window. If you use urine for most substances, urine will give you say a 3-day look back window. You can ask the father's physician. Most states have a prescription drug registry, which is really, it's not, the records are not to be used for criminal prosecution or forensic purposes, but I routinely would speak with a subject's physician to ask, one, to get blood chemistry results if that was relevant, to ascertain their view of whether the person has any indications of a drug use problem. And it is, my workaround is, I think it is reasonable to ask the physician to access that data from the prescription drug registry to see if there is any indication. This comes up a lot in opiate cases where there's intense drug seeking, and so you'll see a hospital emergency room visit for opiates in South Jersey. You'll see different physicians. So I think the workaround is if the physician accesses it and uses as part of their feedback to you, I don't think it violates the prohibition against use for criminal or criminal prosecution or forensic purposes. Obviously, speaking to professional or lay persons about collateral informants, and interviewing the subject not just on the substance use history, but personal history, work lives, and demands. And why I say that in this particular context is you see this pilfering of children's stimulant medications, and it's not for the purposes of intoxication, it's really for performance enhancement. And so one of the things that you do to take care of a situation like this is you tell them, go to your physician and see if you can get a licit prescription for a stimulant, because stealing your kid's Adderall is not legal and it's not advisable. All right, one more. Which of the following recommendations might not be validly made in a forensic substance use evaluation related to a family court matter where the resulting opinion is that there are fitness relevant implications? So which of these can you not recommend or suggest? Take a couple of seconds. This one is pretty straightforward. A is the best answer. It's a forensic substance use evaluation. It's not a custody evaluation, and you have to be boundaried, and the scope of evaluation needs to be bounded by the original order or request for assessment, which is a forensic substance use evaluation. Now, there are cases in which, in a best interest, say a custody evaluation, where a forensic substance use can be embedded within that larger assessment. But if it is a standalone forensic substance use evaluation, there is nothing in the database that would really inform on some of the bigger issues of custody and parenting time. Okay, so let me move on. So what we know is parent substance abuse is a known risk factor for child safety and development. parent role modeling, interparental conflict, financial circumstances, and addiction is raised regularly as a parenting fitness concern, but objective assessment of that is poorly understood, and so assessors can over rely on self-report, and what you'll see is that it tends to be mirrored in courts. So if you have, let's say you have a judge who grew up in a family that was rife with alcohol and chaos and addiction versus a judge who grew up in a household where there was none of that, because judges don't know how to really assess these things, and they, absent this kind of information that you can provide them, there is a very great concern about judicial rulings having to do with a judge's perspective on alcohol, largely based on their own personal experience. And so very important that in these things to communicate with some objectivity and authority what the reality is and what the reality isn't, and trying to bring it's an area where there has been a lot of research on substance use relapse and recovery, because that is always a consideration, and we know from the phenomenology of addiction that relapse is a commonplace occurrence in the recovery journey of people with addictive disorders. So what we try to do in this forensic substance use evaluation is use all the available technologies and protocols to try to come up with some convergent validity that allows you to provide a quality and contextually relevant assessment that deals with practical issues and will withstand cross-examination in those rare cases where things go to trial. Give you a little bit of basic science. These are the important drugs of abuse. I'm going to go through this clearly. What you'll see is there are emerging, faster than we can even process it, all kinds of drugs that like kratom is a drug that comes up in evaluation, but it's legal. Bath salts comes up in evaluation, but I think that they're legal. And you can include steroids and the thermogenic types of substances because they have such an important behavioral profile that accompanies that abuse, and that any of the performance enhancing drugs come up in these types of cases. In terms of epidemiology, alcohol, the most commonly used substance. This just gives you some sense, and I'll let you go through these slides yourself, but gives you a sense of the frequency with which people may use either in lifetime or in a specific period of time various substances. But the figure that for the general population, 2 to 3% of the general population might have a substance use disorder at the time you're assessing, and people, about 10% of the population will meet diagnostic criteria for a substance use disorder in their lifetime. Again, basic science talks about the reward circuit, and why do drugs do what they do? Why does alcohol do what they do? And this is more important than you think, in part because as we go through, let's skip this one. If we look at things like, this is a slide on alcohol and sedatives, things like Xanax or benzodiazepines and alcohol. They're cross-tolerant and very similar. They have their action in the cerebellar and the frontal lobe primarily. And so that kind of explains, why do people who are drunk, why do they stumble? Why do they fail to, why do they exercise terrible judgment? If we look at opiates, opiates work here and they work in the thalamus, and that explains the analgesic effect. Stimulants work primarily in the reward circuit, which is related to the strong craving that the euphoriant effect leads to strong craving. Cannabis also works in the cerebellum and the hippocampus, and this part explains why people who are using THC may stumble, may be uncoordinated, and have problems with memory. And understanding a little bit about specific drugs' effect in the brain is important, because you're trying to link up people's descriptions of how the person is with the substance that they are being accused of abusing to a level of parenting fitness concern. So again, I'm going to go, just to give you a sense of the brain science underneath it. So as I said, there's a lot of he said, she said in these kinds of cases. And if you, there's research to back up all of this, but if you look at the, this is kind of what's at stake here, is that alcohol and drugs, it's well understood, have various types of prenatal, socioeconomic, developmental impacts on children, and that substance abuse, I should say, is always viewed as an aggravating factor for risk. It tends to lower the threshold for bad things happening. And so you'll have immediate and short-term concerns that have to do, and these are the ones that come up in these cases most often, is concerns about the physical and the emotional safety of the child. Whereas the court is less interested in long-term consequences. Of course, they're trying to solve an immediate problem of determining the relevance of the substance use allegation for the decisions they have to make about custody and time sharing. So the forensic substance use evaluation, that's FSUE, is hoping to inform on, provide information that can help the decision makers make their decision, and expert evaluation is essential, because there are very few places where decision makers can go to get expert evaluation outside of forensic substance use evaluation. And one of the things you'll see is, certainly in child protection cases, you see this, and you see this in matrimonial cases, is they will rely on a clinical evaluation. So in the courthouse where I work most often, they have someone, they send people down to the basement to give a urine test, and they make decisions based on that, and a 45-minute interview. It's just it's an inadequate screen, but it passes muster in the court system. It's an inadequate screen for the types of things that the types of questions they're trying to answer, but it's practically what they do. And so you can offer a level of authoritative science and opinion that goes well beyond what might typically be done in cases. In New Jersey, there are roughly 12 factors a judge must consider when making custody determinations. And so how does substance use evaluation and findings, how does that interface with their task? Well, the primary custody factor, is parent fitness. Is this parent fit to parent based on their substance use? But let's see, five other factors this also touches on: stability of the home environment, needs of the child, safety of the child, domestic violence and interpersonal maltreatment, parents' ability to collaborate. Substance use is pervasive in its impact on all of these things. And so if you do your substantive use evaluation properly, you can inform the court, or most cases in Jersey now go to mediation. You can inform mediators about these are objectively the issues. In New Jersey law, two constructs are really important to understand. It's interesting. And the first one is from the Rizzo case, is that a custodial parent's substance use is only relevant to custody if it can be shown that it affects the parent's status in the relationship with the children. The second important law is that, and I don't know that I entirely agree, but it's the law, is that courts have reversed, Supreme Courts or appellate courts have reversed lower courts' decisions for failure to perceive obvious risk posed by continued substance use. Okay, so again, here are the components of a forensic substance use evaluation in family law: the interviews, the testing, the biomarkers, the records, the psychometrics, and careful integration of addiction science. When does a court ask for this? Well, typically when people are getting divorced and one person in their certifications or in their divorce complaint says that the other has an addictive problem, and they have concerns about the child's safety, and these things emerge when people separate. It can be in the active litigation stage where it's never come up, but someone or the child suggests that the parent's substance use, daddy was lying on the floor and I couldn't wake him up. Or and this is an important area in the post-litigation phase, where the task is to validate a subject's claim of stable abstinence and recovery, which is doubted, of course, by the other parent. So those are the ways in which these things come up. The court may order these types of evaluations when the hard data is equivocal, when there are important and irreconcilable differences in the claims, the he said, she said, and that have to be resolved. This is, I'll let you go through this on your own, but this is kind of what is comprised by the clinical assessment by in-house court personnel versus forensic substance use evaluation. What are the differences? How much time is taken? What's involved? What biosamples are assessed? What are the collateral contacts that are made? What is the documentary review, and what is the prognosis? The clinical evaluation just simply say they think the person has a problem, doesn't have a problem, and make some treatment recommendations. Forensic substance use evaluation goes much further into talking about specific risks. Okay, this is We've done that. Okay, so I haven't yet gone through in detail what's involved, but I'm still shaping your understanding. But at the end of an evaluation, the findings, conclusions, and recommendations. One, you're trying to come up with a diagnosis if a diagnosis is called for. You want to document empirical and inferred, and that you qualify your opinions carefully. So if you're making inferences, you have to be clear that those are inferences, and articulate case-specific risks. You identify considerations for treatment and self-help if it's relevant. You're assessing and describing motivations to change and potential for future use. You're trying to predict the future based on what the science has to say. Very important element is to identify strategies, protocols, concepts for monitoring, so that the court will turn to you. How shall we assess this going forward? Is supervision necessary? If there is a parent-child estrangement, how should that be handled, at least with respect to the substance use risks? To anticipate challenges, to document the relevance of recovery to family reunification, and just carefully qualify the confidence in the limitations of what you have to say. These are generally the sections of a report that comprise the forensic substance use evaluation. And so, for example, there's not a section on psychometrics. I tend to weave the psychometrics into, so in the course, and I tend to do the substance use history embedded within family and personal history and the marital history. And when the psychometrics have something to say about a specific issue, they weave it into those sections as opposed to have a separate section. That is increasingly my tendency, is to plug data in where it makes the most sense and is most relevant in the flow of a report. This I'll let you read, but I'll let you read this on your own when you have the slides. But you're interviewing the subject spouse thoroughly, not solely on their drinking, but all kinds of things. And so, medical history, let me just say, medical history is a very important one, because I'm in a case now, for example, where there is ample evidence of the subject being grossly intoxicated at various types of family things and business things. And he's a guy who had bariatric surgery, and there are different types of bariatric surgery, but the type he had was a bypass, and essentially bypasses the stomach, where the stomach has a couple of the acetaldehyde, basically the breakdown enzymes for alcohol. It starts in the stomach. And so when you bypass the stomach, functionally what it means is the person's going to metabolize alcohol much more slowly, so they will reach a higher blood alcohol level and consequent impairment with a standard dose, and that there'll be perturbation of their biomarkers as well. So that it doesn't mean that they don't have a substance use problem, but you need to reference the data on bariatric patients to be able to apply the basic science that you know. Medical history being diabetes is really an important variable, particularly with alcohol. Now, of course, as we all, anyone who's dealt with substance abusers and family court litigants, we understand tend to be a moderately defensive population, and because of what's at stake for them. And so we're dealing with a population that comes in wanting to be evaluated favorably and seen in a positive light. We also understand that substance abusers as a species tend to engage in denial and minimization. So if you those two sources of defensiveness can interfere with the ability to get accurate data, from the subject, which is why we do all these other things. Collateral co-informants can be extremely important, particularly if they don't have as much skin in the game. Lay informants can be very biased. They tend to line up behind the person whose side they're on. But you'll even see that with professionals, with therapists who, over-identify with their client. But collateral co-informants can be really important sources of data. And if I think about now versus in the past, I speak to more people. I may speak to 20 co-informants on a case. That's a little extreme, but I have found the value, just my own experience is the value of their information more important than I may have thought in an earlier stage of doing this type of work. Drug testing is a really important source of information, and by using the better biosamples, hair and or nails, you can get a roughly 90-day look-back window. And so you do this on the front end of evaluation because you want to capture, and most people and most lawyers know that they're going to be drug tested, so they'll caution their clients. So you want to do this in the front end. You want to send people to a lab that will do forensic quality testing with chain of custody, witness samples, all of that stuff, and proper confirmation of secondary testing of positive samples. You also have to know what you're looking for. So, for example, if you ask for drug testing for opiates, the difference between opiates and opioids is opiates are natural products and opioids are synthetic products that mimic or match the chemical structure of opiates. If you ask for drug testing for heroin, you're not assessing for some of the synthetic opiates. The names are escaping me right now, but be very specific about what you're asking for. And usually something like a 17 panel, very demanding, very expensive. But in opiate cases, you want to get all the synthetic opiates too. So be very careful what you're asking for, and ask for more rather than less. Obviously, when you're asking for forensic quality, the lab understands that you are asking them to also, to the extent that they can, test for adulterants or masking agents. Biomarkers, independent of drug testing, biomarkers really relate to alcohol assessment. 20 years ago, nobody tested for alcohol because there were not reliable biomarkers. There are now, but 20 years ago, if you were testing someone for alcohol, either they had a positive blood alcohol level or they didn't. And if you think about that as a screen, it's a very weak screen because you kind of have to catch them when they've been drinking, and if you think of it as it's a net with very wide holes. But in more recent years, the science has led us to understand that there are metabolic footprints, is the way that I think about them, that alcohol leaves and can be assessed. And there are indirect biomarkers. An indirect biomarker might be ALT or AST. Those are typical blood chemistry measures of liver and kidney function that are routinely taken when you get a physical examination. Alcohol will tend to drive them up if the consumption is heavy enough. But there are many things that can cause an indirect biomarker to be at high levels, and it doesn't. MCV, mean corpuscular volume. For some reason, people with alcohol problems have big fat red blood cells, and so that is an indirect biomarker for drinking. However, there's lots of conditions. If you've hurt yourself and you're manufacturing a lot of blood, your MCV will be elevated. The best biomarkers for that are even potentially dispositive are ETG. ETG is I think it's ethanol gluconide, and PF is phosphatidylethanol. Phosphatidylethanol, again, you don't use them standalone, but the value of phosphatidylethanol, for example, would be it's almost like A1C as a measure of blood glucose. It is an average estimate of the amount of alcohol consumed over a period of time prior to the test. So, for example, an elevated PEth level can tell you that the person consumes, on the average, roughly 4 to 6 drink equivalents a day over a period of months. That's really important data. And the value of PEth is, there are only 2 reasons I know of that PEth can be elevated, because it is a direct biomarker, only produced by the consumption of alcohol. So the 2 reasons would be lab error, and the other reason would be that the person drank heavily. So it's very valuable. ETG is a little bit different. ETG can give you some of that, but ETG was developed as kind of a binary measure. Has the person consumed alcohol, or has the person not consumed alcohol? And so there are cases in which a litigant is ordered not to drink, period. Sometimes the cases, are don't drink when you have the kids, 24 hours before you have the kids, to throughout the period where you have the kids, don't drink. But there are some cases where the person is not to drink at all. So ETG can be a very useful measure for determining whether the person has or has not complied with that order. ETG has various weaknesses in it as well. There was a study of, this goes back to the 1980s or 90s, a study, they wanted to do a study on the prevalence of alcohol use disorder in hospital medical workers. And so they took ETG measures, and the data at the outset looked like, virtually 100% of hospital-based medical workers had drinking problems. And the reason for it is that population uses a lot of hand sanitizer that's alcohol-based, and so there was transdermal absorption of an alcohol that tested positive. So ETG has, you have to, if you're going to use it, you have to screen for various things fairly carefully. But again, it can be a really good measure, binary measure for has the person consumed alcohol in a period of time or not. This you'll look at on your own. These are various of the measures that can be used as traditional markers for alcohol. You don't need me to really go into a lot of detail, but there are very useful psychometric. This is an example of what an alcohol use inventory. The alcohol use inventory is a structured self-report instrument that has a factor structure that gives you information on social improvements and mental improvements. What are the benefits to the person of using alcohol? What are the styles of using? Are they sustained or are they binge users? What types of range of consequences have they had? So what I give you is later and you'll see it in the slide deck, is selected measures for various types of metrics that you can use to supplement and inform what you learn from your interviews and other sources. Various types of discovery materials. All of these things can be useful. Any records that, driver's abstracts are important. Prescription registry data can be important, although you can only access that through a physician who's assessing their own client. You want to see if there have been prior experts who've studied this. What have they had to say? So I tend to ask lawyers to send me everything you think that might be relevant to my task, and with the understanding that I can cull anything that's not. Yeah, I won't bother going through the DSM or the DSM-TR. There aren't too many changes in the TR, but from 4 to 5, 4 to 5 was the change between that brought us to the current notion of substance use disorder that varies in terms of severity. Okay. These are the diagnostic criteria, and you always want to link. You want to come up with a diagnosis if a diagnosis is merited. So you want to link the criteria to the database that you've collected. The subject-spouse interview is you're going to ask all of these things of like, what did they drink, how often, what frequency, how much, what were the effects, did they show? You try not to ask it in a leading way. So you don't, how many times did they fall down the stairs, or you want them to provide you with their observations of the person's substance abuse. This is much more than you would get from a collateral interview. There are a number of semi-structured interview protocols. So if you don't want to wing it, you can use any of these to guide you. And what we find is that most people who've been doing this a while tend to weave things from these interviews into their own interview. Non-criterion assessment, things that are not particularly related to diagnostic criteria, but do bear on whether someone has a substance use issue. Skip that. I'm not going to have time for that. I'm sorry. So I'm going to skip through and take you to the clinical history. The Addiction Severity Indexes are really good. It's free. It's downloadable. You can be trained in it. It's a very useful instrument. Some of the different instruments that you can use to guide your interviewing, and some of the most useful psychometrics. Again, I'm gonna run you through this really quickly. You can read it for yourself. You can call me or email me with questions. I'm running out of time, but here is a rendering of recommended instruments for different types of problems. So once all the data are collected, a comprehensive report is prepared where you explain the nature of the referral, the background, you review what you did, and you itemize all the data you collected. You review the life history and their addiction career embedded within that. You summarize the database and you integrate the data using, most forensic psychologists are very comfortable with the notion of structured professional judgment, that you're using your skills and your knowledge to formulate the best explanation for the database that you can come up with to try to give a valid account of the possible substance use and any comorbidities. Sometimes comorbidity, in these cases, the comorbid condition is actually more relevant than the substance use for parenting function. In your findings, conclusions, and recommendations, you address the history, that the comorbidity, the prognosis and relapse risk, and there is good data on that, how to think about that, and also to inform the courts, the lawyers, and the litigants that it is reasonable to expect relapse, and whether it's a slip or a relapse has to be determined. But it is really important to let people know that this is a foreseeable future risk. And I've developed something, I don't really go into it here, it's proactive relapse monitoring, where you set up an agreement between the litigants that essentially the complainant spouse has a path, you chart out the pathway if they perceive that the person is on the cusp of slipping or seems, they stop showing up for parenting time or something gives them, is kind of making their spidey sense tingle. So that you give them a pathway to get this looked at without having to go to court. And similarly, you make the argument with the subject who, let's say, is in recovery, that if they feel that either they have a slip or relapse, or they feel they're on the cusp of one, to proactively disclose that, and in a particular way that that manages the situation, because it is much better for the family situation if the person discloses that they've had a slip, then all of a sudden they're no longer driving, the parent is driving them to parenting time. You find out eventually that they got a DWI. Much better for the subject spouse to be proactive in terms of if they've had a slip or a relapse, or if they foresee one coming and they need to digress from parenting, say for a period of time because they have to go into treatment or something. Much better, much more collaborative approach. And I think it strains people's credulity to think that you can build a collaborative approach post-evaluation, but actually you can. These things work very well, and at least in cases where you can get a modicum of cooperation between spouses.
We are at the top of the hour, so okay. I did want to thank you so much here. We can certainly recircle back to some final points there. I do want to make sure people have time for their question and answer, and also, of course, people to note that they are at the top of the hour. We do have the links for the CEU surveys are in the chat box. They do work. The QR code Bill's put up there for you to be able to scan if that is another option for you. People have been very appreciative of the overview here that you have. Some things that were coming here at the end is this is clearly a very detailed and comprehensive approach, and some are wondering, like, also seems like it could potentially be very expensive. So who often pays for these in a high conflict divorce or custody case?
Litigants.
Litigants themselves, okay.
If in now, I would not generalize from New Jersey. New Jersey is a fairly wealthy state, and that it's quite correct. I think that a reasonable median cost for full forensic substance use evaluation is something like about between $4,000 and $4,500. So it is out of the means of the average person. But I think that by mastering what a full evaluation looks like, with some experience, you can pick and choose. You can take parts of this and apply it in situations where, it's like, I'm not going to get political here, but it's like many things in the countries. If you have wealth, you can afford to seek justice, and if you don't, you're kind of stuck with what you're stuck with. That answer the question?
Yes, I think it does. Yeah, thank you so much for that. Somebody else asked that, if possible, can you talk about how to evaluate claims of false positive tests? Obviously, collateral sources are important, but are there more common reasons for false positives and ones that aren't, relative to what actually comes up when people say they have a false positive?
I can do that anecdotally. And anecdotally, when a litigant is adamant that the test is a false positive, you have to tune into that and try to make sense of it. I was on a case recently where a person tested positive for fentanyl. They were adamant. Now, they had a history of opiate problems, but they were adamant that they had not used. And what I was able to determine from the research, I assessed all of the medications as a person who had a lot of illness, and they were on, I think it was trazodone for sleep. And there is literature that trazodone can cause false positives. I think that when someone claims a false positive, you really have to look at the literature. There is a lot of literature. If that person wants to email me, I can send them some references. But for every substance, there is the potential for false positives. And but the criterion I use is the adamance, if that's a word, of the subject insisting that they didn't use. Or you can't really determine whether it was or wasn't a false positive. All you can do is inform the decision makers of what the potential is, what the risk is, what some of the research will give you. 7% of positive tests are considered false positives. That's how I would address that. But certainly that person can email me and I can orient them to some stuff.
Thank you for that. Somebody asked, and this certainly is likely to vary depending on the laws in each jurisdiction. Someone said, as far as videos of the spouse using drugs or alcohol is concerned, I assume consent to take videos or photos is not given. So is there an issue with this being viable in court? Just like ethical considerations of these kinds of videos where someone hasn't given consent.
Well, my understanding of New Jersey is for anything that's recording is it doesn't require the consent of the recorded person. New Jersey is not a two-consent state. So two things happened when it comes up in cases. it's really a legal argument that has to be made, and either the court will admit the evidence or disallow the evidence to be utilized. In my experience in New Jersey, evidence, when they put it to a test, kind of the constitutional aspect of this is usually trumped by the best interest standard. And so judges tend to allow the provision of that data.
Thank you. Have you seen, with research on THC potentially increasing the onset for risk for psychosis, have you seen this brought up in any cases at all?
No, you know, I have working familiarity with that literature, and my sense of it, it's not, this is not a scientific opinion, it's just a personal opinion, is that usually comes up in situations where there was someone who already had some type of psychiatric vulnerability that was exacerbated by substance use, as opposed to that the psychosis was caused by substance use. There are situations, for example, there are alcohol withdrawal syndromes that can look very much like psychosis, and you know, but with THC, I think it's usually that you're dealing with a vulnerable population, where the drug causes a disturbance in an already disturbed personality.
Great. And this question was asked early on. I think you started to address some of it later on in the presentation. Someone was asking about differences in quality of hair follicle testing versus urine or blood testing for substances. Are there differences in look back periods? Other important things to know when making recommendations for ongoing monitoring of parents with substance use histories?
Sure. To the extent that, let me say it this way. Most people, and remember, I said at the beginning, this was a gray area. These are gray area cases that you get. So that these are often not people who are, say, end stage alcoholic types with multiple health and cognitive, and you know, who show the signs of frank impairment. These are the gray area cases, and so you want, and the implication of that is most people in these cases can not use for periods of time when they're under scrutiny. And so as a general principle, you're going to want to use hair rather than urine, because hair, for each half inch of hair, you get approximately 30 days look back. So you can capture about a quarter of a year with a 1.5 inch sample of hair, and that's the standard. Whereas with urine, you go back 72 hours at most, for most substances, with the exception of cannabis and heavy users, because cannabis lodges in fat cells, and so eliminates from the system more, for heavy users, more over a couple of weeks. Blood is, I can't think of one case where blood was used as the biosample. Fingernails, I've had a few times. I don't know how that's handled, but I think it is considered similar to hair, because they're the same material essentially. What else can I say about it? I mean, I think that you want forensic quality testing. You want the biggest look back window you can get, because that will give you better data. And if you do it on the front end of evaluation, you're more likely to capture something than if you do it on the back end of evaluation. There are situations in which you might perform a drug test twice. If there's, sometimes when people are drug tested, they figure, okay, now I can go party, and so that you can capture that after the fact. But generally, when you make monitoring recommendations, for example, there's a lot of reliance on SoberLink. I assume that's throughout the country as a alcohol measuring technology that gives blood alcohol levels. It takes a picture of the substance, the sample provider, so that it's the person who is the subject is actually providing the sample, and then Bluetooth shoots it to wherever you've authorized it to go. So that's in the moment monitoring. In the conclusory section of report, there is almost always a requirement for some sort of monitoring, and that's simply, it's not for the purposes of harassment of the subject. It's to make it objective, so that it deals with the complaining spouse's, I think she's using, or I think he's using, and the response, no, I'm not. So it makes it objective, and rather than have people do a urine test strip or a saliva test strip every time they have parenting time, getting a hair sample quarterly is much less demanding on the subject. What it doesn't do is address in the moment use, so that there's always some provision for that too.
Dr. Frankenstein, Bill, thank you so much for the work that you've done in this area, and then secondary, giving us a thorough ins and outs of an evaluation that I think many of us are not familiar with, but that one that we very well could encounter, in an issue that is very relevant to a lot of family court relevant cases. I know a lot of people have mentioned their eagerness to look at the slides later on after this presentation for that content. And so this information is much appreciated.
That's great. I hope I didn't go too fast or was too superficial, but you all know where to find me.
Indeed. Thank you so much, Dr. Frankenstein. And that wraps up this week's Law and Mental Health series. Next week, Dr. James Andretta will be discussing identification of survivors of child commercial sexual exploitation. We hope to see you then for another great discussion of issues in behavioral health and the law. Until next time.